this is the new frontier, right? You know, the world basically is different today than it was about 20 years ago. And I say that because the reality is probably the most dangerous snitch in your client's case is this thing, right? The cell phone that's got the pictures of him with the guns, that's got the text messages, that's got all sorts of bad crap on it that is going to be used to throw your client in jail for a long time. And one of the biggest pieces of information that this little snitch can reveal about your client is where your client is. Not only where is he, like, if they're looking for him, like, hey, this guy's got an arrest warrant, let's go find him. But, hey, where was he 6 months ago? Did he happen to be by that burglary or that robbery? Hey, maybe he was by that other robbery that we never solved or we never figured out who was responsible for. And this is how law enforcement is operating these days. So it's important to understand the technologies. It's important to understand some of the legal issues surrounding these technologies because it's in a lot of flux. And I think most critically, particularly when we're talking about how can we zealously represent our clients, the key takeaway that I really hope you take from my time with you folks this afternoon is to realize that just asking the questions and digging a little bit deeper into some of these issues is going to get your client a good result, even if it doesn't mean you win the suppression motion. Because as you'll see, the government does not want to talk about its toys, and they're going to make your client's case go away instead of reveal details about this technology. So that's what we're going to talk about today. I'm going to leave time at the end for questions. So please keep some in mind, and I want to leave about 10, 15 minutes to answer any questions that you have. And I'll start by asking, who here has had a case that involves cell phone location information in any form? Okay. So a lot of people, maybe about half the people here raise their hands. But just so that we kind of have a basic understanding of what specifically I'm talking about, I've put this map up. This is a map from a federal criminal case. Anyone recognize what city this is a map of? It's actually a city not far from here. This is Baltimore, okay? And basically, this is a case, the case is called United States versus Graham. It's pending in the Fourth Circuit. Graham was charged and convicted of a whole bunch of robberies, armed robberies. And basically, this is a map that details all of the cell phone towers that Sprint operates in the greater Baltimore area. And more critically, it shows all of the cell phone towers that Graham's cell phone connected to over a 6-month period of time. So here's the technology 101. Let me ask a question I know everybody's going to raise their hand on. Who has a cell phone? Okay, everybody has a cell phone. Well, your cell phone has a signal, right? If I'm a Verizon customer, so I've got 4 signals. If you're an AT&T customer, you've probably got 1 signal. And so, your phone has this signal. Well, what does that signal mean? Well, it means you're connected to a cell phone tower. And that cell phone tower is what allows you to get a phone call or get an email or get a text message here while you're in Wilmington attending this seminar. The way phones work is they basically register with the cell phone towers in the area, basically say, hey, I'm here. If I get a phone call or I get an email, please send it to my telephone. And phones do this through some magical, crazy technology I couldn't even begin to understand and explain. But all that matters is your phone is registering with cell phone towers in the area when it's, when the phone's in that area. And the cell phone companies keep a record of which towers the phone connects to. Now, they say it's for some sort of business purpose. It allows them to figure out where they should put more cell phone towers. So that AT&T service can become a 2-bar level of service instead of a 1-bar level of service, right? And so that's ostensibly the business purpose for for keeping this sort of information. Of course, though, it becomes a windfall for law enforcement, who can go to the cell phone companies and basically say, hey, Hanni, we want the last 6 months' worth of the cell towers his phone registered with or connected with. And that's what they did in Graham. They got 6 months' worth of cell phone tower records, It revealed 22,000 different data connection points. So that could be 22,000 different times his phone connected to a cell phone tower. It could be the same phone tower multiple times, which would suggest a place that he's probably at more often than other times, like your house, employment place, your school, whatever it may be. And then, of course, they use this to say, well, look, Graham was, around the bank robbery at the time it was robbed, right? Or he was around the, his phone and the victim's phone were right next to each other, and then the victim's phone was left in one place, and that's where they found her body, and then we see the defendant's phone is moving up north 20 miles away. Okay, so this is how this type of information is generally used in criminal cases. Now, the big legal issue on this is what is the judicial process or the legal process by which law enforcement can get these records? And this is where there's a lot of legal debate, which we're going to talk about towards the end of the conversation. We're going to talk about the law towards the end. There is a second piece about this that I want to flag and not discuss in any detail because we just don't have enough time to discuss it, but note that this is another part of the legal issues. And that's the Daubert question, the reliability question, and poking holes and challenging how precise these types of records are. I acknowledge that that's an issue. We don't have time to get into it today. I'm happy to stick around and ask, talk about it afterwards, and I'll be here tomorrow, obviously. But just keep that in the back of your mind. But for now, let's just focus on some of the technology here. So that's Graham. That's the cell phone tower information. Us geeks, we call it cell site location information. Sometimes you'll see it referenced as historical cell site location information. So that would be law enforcement goes to AT&T and says, give us the 6 months worth of the records that Hanni was connected to. You could sometimes see it labeled as real-time cell site location information. So real-time would be the cops call Verizon and say, we need to know which cell phone towers Hanni Fakhoury is connected to right now. And Verizon will say, OK, sure, here you go. He connected to this tower. And then law enforcement can say, OK, give us updates every 5-10 minutes. And Verizon will say, sure, here you go. And they'll give real-time live updates. That's cell phone tower information. This stuff is pretty common in federal cases. And even when I was a federal defender and handling these cases, I would get them back in the, not that back in the day, but I would get them. And to be honest, as a kind of a newbie federal public defender, I literally had no clue what I was supposed to do with it. I didn't know to challenge it. I one time got a stack about this thick on the day of trial, the morning of trial. We were about to pick a jury. And so I was just like, well, are you going to use it? And they're like, maybe. I'm like, OK, well, if you decide to use it, let me know, because I've got a million other things I've got to think about right now. But this is common. We see it a lot in federal courts. We see it a lot in state courts, and about half the people raise their hand who have seen this type of technology. I'm assuming that they've seen it in their cases. Okay? So that's one piece of it. This is the common piece of it. What I'm going to spend most of my time talking about is the really secret shit that they don't really want to talk about. Okay? Because this stuff, we'll talk about the legal challenges and whatnot at the end, but I want to unpack more the secretive stuff. So what do I mean? What I really mean, and what I want to start by talking about, is stingrays. Anybody heard of a stingray? And I don't mean the fish, okay? The technology stingray. Okay, so a couple of people. A stingray is a brand name of a technology called an IMSI catcher, okay? An IMSI catcher. What's an IMSI? I-M-S-I, IMSI. That stands for International Mobile Subscriber Identity. It's a serial number for your cellular phone. What does an IMSI catcher do? Well, an IMSI catcher is a piece of technology that scans and captures all of the IMSI numbers in a given area. And armed with the IMSI number, law enforcement can go to the cell phone company and say, who is the cellular phone subscriber associated with this IMSI number? That's what an IMSI catcher does. Now, how does this thing actually work? I think this is a pretty good illustration of it. This is from an article that was in USA Today a couple years ago. Think back to what I just finished talking about, the way the cell phone connects with the cell phone tower. Okay, so your phone connects to the tower. It says, I'm here, register my calls. The cell phone tower is operated by the cell phone company. And they have all sorts of agreements about sharing bandwidth, and none of that really matters. What matters is, if you see in this graphic, there's somebody in the middle. Okay? That's the Stingray. And if you look in this diagram, it's a picture of a van. Well, who do you think is driving the van with the Stingray? It's the cops, okay? The cops are driving the van with the Stingray. And what they're basically doing is they're operating what we call in the kind of like the geek community as a man in the middle. The Stingray gets in between your cell phone and the cell phone tower, and it scans to capture the IMSI number that your phone number is sending out to the cell phone tower. So the cops can put this thing in a van. They could drive around. There's a portable device they can hold in their hands. And they can basically use it to find IMSI numbers and ultimately to find people. There's two ways they could really do this in any kind of meaningful way in a criminal case. The first would be, let's say there's a political protest. There's a, unfortunately, as we see in the news every day, there's some, protest about police brutality, killing of a young African-American unarmed man by the cops. There's a big protest. The cops are all freaked out. They want to make sure they know who's in the area. They go park a van with the Stingray on. They flip it on, and they're sitting there. They're scanning the area. Let's see who's around. Make sure we can keep tabs on who's here. So they're capturing the IMSI numbers. Now, I don't want to freak everybody out too much. They're not capturing the conversations that are happening over cell phones. They're maybe not capturing the text messages, but they are able to identify the individual cell phones. They could then take those IMSI numbers. They can figure out, hey, who was at the protest? Hey, Hanni Fakhoury was at the protest. Hey, he's got a felony conviction. Oh, look, and he's on probation. Let's go check him out and see what he's up to. That's one way they can use it. Another way they can use it is, let's say I'm a fugitive. I've just carjacked somebody, and they're on the lookout for me. They can take the they can take the Stingray. They know, let's say they know my cell phone number. They know that I've got this phone. So they can program the Stingray to look for my phone number, and then they can drive around and use it like a honing device to figure out, hey, is he over here? Is he over there? Where is he at? Okay? And then they can use this and basically find fugitives, find people who are wanted in the justice system. So those are kind of the two main ways the device and technology can be used. Now, this thing necessarily works by scanning all the phones in the area, right? Even if it's used to find one person, it's got to work by a process of elimination. So in order to figure out that I'm not the person they're looking for, or the phone that I have is not the phone they're looking for, they've got to scan and read my IMSI number and then decide, oh, that's not him. Let's keep going over here, okay? So it's necessarily capturing a lot of information about people who've actually done nothing wrong. So that's just like a generic privacy violation, okay? And then with respect to your clients, the question becomes, how are they operating this thing? Are they going to the courts? Are they getting a court order? Are they telling, judges, hey, we want to use this device. Are you going to approve us? Are you going to let us do it? As you're going to see, the answer is they're not doing that either. They're not telling anybody about the use of these technologies or the use of this device. And we're going to get to that in a second, but I want to also kind of bring home the point that this thing is here in Delaware, okay? How do I know that? Well, let me start by saying who has it. Well, here's who has it. Your federal agencies of alphabet soup, FBI, DEA, the marshals, DHS, customs, you name it. All the feds have it. Okay, that's fine. Here is a map the ACLU put together of all the state law enforcement agencies that they know who have one of these things. Okay, I'm from California. We've got them. If you look on the East Coast, it's kind of, maybe it's a little hard to read. Delaware is gray. Gray means at the time this map was produced, they didn't have an answer to whether one of these things was in Delaware. But guess what? Delaware has one. How do I know? The state police has admitted that they have one in a letter dated just 6 weeks ago. So it's hard to read this letter, and I apologize for the small font. But basically, there have been a lot of Public Records Act and FOIA requests and litigation on these devices. And one guy basically sent out a request to a whole bunch of law enforcement agencies, including the Delaware State Police. And this is the response he got back from the Delaware State Police that he shared with me. And it basically says, blah, 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 based on what the AG and the cops and everybody has told us, there's a non-disclosure agreement. We can't get into any details. Your best bet is to go talk to FBI, Harris, or Boeing. Why Harris? Why Boeing? Why the FBI? Well, Harris is the manufacturer that makes the Stingray, right? I said Stingray is a brand name for an IMSI catcher. The actual device is made by the Harris Corporation, which is a Florida company. Boeing makes a variation of this technology. It's called a dirt box, a DRT box. The DRT boxes is what the US Marshals Service uses. So the Marshals have one of those things. And there was an article in the Wall Street Journal a couple of months ago that talked about the Marshals would slap on these dirt boxes onto airplanes and fly them around the DC area, and then up, including Baltimore and probably Delaware, to look for suspects that they were, had arrest warrants out for or whatever. And why the FBI non-disclosure agreement? Keep this in mind. But basically, what this says is this is here in the state, and they don't want to talk about it. Okay? So it's on you to figure this out and to find out if it's being used in your case. Now, the problem is, like I said, they don't really want to talk about it. And one of the reasons they don't want to talk about it is they've actually been instructed not to talk about it by the FBI. So this is, let's go back a second. Oops. If you look here, it says there's a non-disclosure agreement is the property of the Federal Bureau of Investigation. What is going on here? Let's unpack this a little bit. How does the state police buy one of these things? First of all, these things cost about $500,000 to buy. Okay? It requires training. And guess what? Harris says if you want your cops to get trained, you bring your cops to Florida and we'll train them there, or you fly us up here and you pay for it. The training itself costs about $20,000 a year. Okay? The device itself costs about $500,000. So how does a state buy one of these things? Well, what they do is they go to the Department of Homeland Security, who offers them a grant to buy one of these things. So DHS will say, local police department that has no money in a state that is perpetually broke, AKA every state, okay? We're going to give you a grant for policing purposes. And the grant is for $500,000. Police department says, great, free money. What are the strings? So what are the strings? Well, the strings are, one, you can only use it to buy a Stingray. Two, you have to buy it from Harris through a sole source contract. You can't open it up for bidding, even though most state procurement laws require there to be a bidding process. Three, when you buy the device, you sign a non-disclosure agreement with Harris, the manufacturer, and you sign a non-disclosure agreement with the FBI. So that's why there's all this discussion about a non-disclosure agreement. Let's look at the non-disclosure agreement that the police in Baltimore, the city of Baltimore, signed. So Baltimore, also not far from here, they have one of these things. Let's take a look at the non-disclosure agreement that they signed. So this was obtained through Public Records Act litigation. It's dated in 2011. Okay, it's hard to read this. I kind of zoomed it in. By the way, if you want a copy, I'll send you a copy. All my materials, are just email me. I'll send you whatever you want, including this, so you don't feel the need to write anything down I'm saying. Just listen. Okay, here's what the non-disclosure agreement says. One, the Baltimore Police Department will not, in any civil or criminal proceeding, use or provide any information beyond the evidentiary results of the Stingray in any pretrial matter, search warrant, related affidavit, and in discovery. Okay? Let's unpack that. So what they're saying is, you, police department in Baltimore, when you go to get a search warrant, you don't mention the device. When you make discovery, available to a criminal defendant, you don't mention the device. When you are in court and you're swearing out the affidavit, you don't mention the device. You don't testify about the device. You provide no information about the device beyond the evidentiary results. Well, what is the evidentiary result of the Stingray? It's, we found the guy. That's the evidentiary result. So if you get a search warrant affidavit that says, hey, we were looking for suspect and obtained information that he was at address Y, maybe it's this thing, because that's the evidentiary result, but there's not going to be any reference to the actual device. Okay? It gets worse. Well, actually it gets better, kind of, in a weird way, but it gets better in the sense that, again, in this piece of it, it says, if you enter into a situation where you are ordered to disclose information about this device, you are instructed to dismiss the case. That's what the FBI is telling local law enforcement. So Now, I give this talk to a lot of people, right? And so when I talk to people who are thinking about privacy, right, I say, this is terrible. Where's the public safety? Now, when I talk to the public defenders, I say, you better hope and pray your client got arrested by one of these things because he's walking home free. Okay, so I'm with the public defender folks. So yeah, you better hope they use it in one of your cases because you're going to get a dismissal. Okay? Because that's what the FBI has instructed the police to do. Now, this is the agreement in Baltimore. I've seen the agreement in Buffalo, upstate New York. It's identical. I've seen the agreement in San Bernardino. It's out in California. It's identical. This is the agreement, period. So if you've got a local law enforcement agency or a sheriff or whatever using one of these things, they've got one of these agreements with the FBI. I want to spend a little more time actually talking about just how the depths of which they will go to cover this up. This is internal email. So one of the best things about public records law is shit's public record, right? And this is internal email correspondence out of Florida. I can't remember where exactly in Florida, but this is Florida police officers having an internal discussion over email about the Stingray. Now, the beauty of it is all their email communications are open to public records laws. So what happened in this email conversation? Basically, some young buck deputy police officer submitted a search warrant affidavit where he referenced the Stingray device in the search warrant affidavit. Well, young friend, he made a big mistake because this is the result that came out of it. An email from the captain basically saying, well, I'll just blow it up. At the request of the US Marshals, what we do is we basically don't reference the Stingray. We say it was a confidential source. So go take back the search warrant affidavit you submitted, resubmit a new search warrant affidavit, use the words that we received information from a confidential source. Now, the beauty of this is, I mean, I don't even know where to begin, right? Like, you've got documented evidence. We say the cops lie, right? We know the cops lie, right? But they're literally saying they lie. That it's their office policy to lie on the direction of the FBI and the US Marshal Service. That's crazy at the Stingray level. But it's crazy like, well, any case involving that officer, we're reopening any case where that officer submitted an affidavit or wrote a report or testified. Because now he's a documented liar. We don't have to even make this up. We're not have to speculate about it. We've got proof, concrete proof. That's the policy. We've got to reopen every case now. I don't care if the Stingray was used or not. It doesn't matter. Every case open for re-examination now. This is another one. This is back in my neck of the woods. This is the U.S. Attorney. This is that's the state police. The feds do it too. This is internal emails, again, through FOIA, so that's the Federal Freedom of Information Act, where basically there was apparently some internal discussion amongst the federal magistrate judges up in Northern California, where I am, where they were mad and they were concerned that the officers, and really they're dealing with FBI agents and marshals, weren't being forthright about their use of the technology. So they were reminded by one of the higher-ranking U.S. attorneys who sent this out to all criminal staff of the U.S. Attorney's Office in San Francisco and San Jose and Oakland, that, hey, just make sure you're actually referencing what you're doing in, when you're using these devices. I highlighted this last part, and I know it's a little hard to read. It says, it's recently come to my attention that many agents are still using WIT technology. That's wireless intercept team. That's Stingray. Okay? Technology in the field, although the pen register application doesn't make that explicit. Okay? There's two issues there. The first is they're saying they're not being completely forthright about what they're doing. The second thing is they are using the authorization granted under the federal pen register statute to operate one of these devices. And as we'll talk about a little bit later on when we get to the law, that's actually legally problematic from a statutory point of view, at least under federal law. But it's the exact pattern and practice you're going to see in almost all of these cases, where law enforcement is going to say, oh, no, we went to court. We got a court order. But that court order is really just your basic pen register order that you may see in a million other cases, but it's being operated, that authority is being used to operate the Stingray device. I'll give you, here's an example of it. This is out of a federal criminal case. It's a tax fraud case. So they're not even using it for violent, they use it to find a guy charged with tax fraud, okay? Like not even a real crime, basically, right? It's crazy. So in this case, this Rigmaiden, very interesting case. Rigmaiden, he's one of those clients, okay? He had like 3 lawyers, and then finally was like, no, I can just do it better myself, okay? And so he was pro se, but actually he did a really good job in his case. And he basically would file these 300-400-page motions, okay? Which, you laugh, right? But I talked to the federal judge who presided over his case, who said it was better than 90% of the briefing he would get in his regular docket, especially in civil cases, okay? So anyway, he was able to get the government to turn over in discovery all sorts of records and information about the Stingray device. This was one piece of it. This was the quote-unquote court order. Actually, the government claimed this was the search warrant that allowed the government to operate the Stingray device. Now, if you've done any federal practice, okay, federal search warrants all look the same, right? They have like a very standardized look to them in the front. And long story short, they don't look like this, okay? More critically, this order is directed to who? It's directed to Verizon Wireless, and it orders them to provide information, okay? So if you, having heard nothing about a Stingray, you would think, okay, this is just the standard deal. They went to Verizon, Verizon turned information over. That's not what happened. They took that, and then they said, okay, great, let's get in the van, let's pump the Stingray on, let's get some AC/DC going, and let's go find this guy. And they basically, the way it actually got worked in Rigmaiden, the way it was used was they used it to figure out, they went to an apartment complex. They knew he was in an apartment complex, but they didn't know which apartment was his. So they operated the device and went around the apartment complex sniffing out where he was until they found him in this specific apartment unit. And they said, boom, 245, all right, let's go get that search warrant and knock his door down. And that's how, and this is the authority they use to get there. So it says it's an order, it's directed to Verizon, turn over information, but they're actually operating the device themselves in a way that is clearly not contemplated by this order. So that's another example of how they hide this in the details. The Rigmaiden case was litigated in like 2013. After that case got litigated, a lot of people started to get very interested in the Stingrays. And they started to do, a lot of like reporters started to do Public Records Act requests, FOIA requests. The defense bar started to pick up on it, started to make noise in their criminal cases. And ultimately, we've started to see a real big shift and a real big sea change on how this technology is being discussed and handled in court cases. So I'm going to give a couple examples of this. In Tacoma, Washington, okay, so not far from Seattle, police there, the judges found out that they were authorizing Stingrays when what happened? Well, when they read a newspaper story about it, okay? So the court orders that the government got, court orders that presumably the judge has read and authorized and signed, they actually did not know what they were approving or signing until somebody read about it in the newspaper. After they read about it in the newspaper, they were understandably a little pissed off about it. And basically went and had a meeting with the police department and said, yeah, that's not going to work. You're going to have to actually tell us what it is you want to do. And once you tell us what you want to do, we'll approve or we'll deny as appropriate. And the big advantage of that is then we're going to get more information in discovery, and then we can litigate this stuff. And we can actually have meaningful debate about what are the legal rights and requirements and protections that apply with this technology. But it's not going to work if the judges are finding out about it through newspaper reporting, okay? This is another example. This is in Charlotte, okay? In Charlotte, same thing. The judge, apparently the courts there had approved this thing 500 times, but didn't realize what they were approving until a judge read a newspaper story about it and then denied the request that came to his door the next day for it. And it was the first time the request had been denied. But again, knowledge is power here, right? Once they actually figured out what was going on, they had some real questions and concerns about it. This one is my favorite. This is out of Baltimore, and this is actually a public defender case. The public defenders in Baltimore did a fantastic job in this case. Remember I said they're instructed by the FBI not to discuss the technology and not to discuss the details of the device. In this case, public defender very cleverly, very smartly figured out that the cops were using the device, started, on a motion to suppress, started to cross-examine the officer about it. The officer said, I can't answer those questions because of a non-disclosure agreement. And in a beautiful scene, the judge said, well, you know what? You don't got a non-disclosure agreement with me. So you're either going to answer the questions or I'm going to hold you in contempt. And the officer said, okay, I'm not going to answer the questions, okay? At which point the prosecutor basically intervened. And what did the prosecutor intervene? He submitted on the motion to suppress, okay? Raise your hand if you've ever had a prosecutor submit on a motion to suppress. Wow, I'm buying you a beer afterwards, okay? I've never had it, right? I mean, they literally were like, you know what? Fuck it. We're not even going to, you know, we're not even going to, sorry, I promised I wasn't going to, I can't help it, okay. Yeah, they basically were like, no, we can't even get there. So they just said, forget it. We're not going to use it. We're not going to use the evidence. Throw it all out. And it was like they threw out a gun, they threw out a bunch of other stuff. Okay? They submitted on the defense motion. Here's another example. This was in Florida. This is crazy. This guy was charged with robbery. He robbed some drug dealer with a BB gun and got like $100 worth of weed. But Florida being Florida, the guy was charged with like a 4-year mandatory minimum sentence. Then they found out cops used the Stingray to figure out where he was. So the defense attorneys, also I think public defender office there, did some discovery challenges, litigation, basically got the judge to basically order the police to come bring the Stingray device to the defense to analyze it, to have them inspect it. You think they did that? No. They gave the guy a 6-month probation deal and the case went away. Okay? So he went from 4-year minimum, 6 months probation. Right? Now, you probably should have been given 6 months probation to begin with for a $100 marijuana robbery with a BB gun, but that's a different issue for a different day. The result is just asking the questions and poking around got a good result for the client, even though they never actually litigated the underlying constitutionality of it, right? And this was written up in the Washington Post. Okay, oops. So there is a lot to be gained by poking around and asking questions because they are instructed not to turn over information. By the way, I just gave you a sample. I have more examples of cases being dismissed. Actually, a couple weeks ago, the St. Louis Post-Dispatch wrote a whole story about a robbery case being dismissed because they didn't want to talk about the Stingray. It got dismissed coincidentally, and according to the DA, and no connection whatsoever to the fact that it got dismissed the day of the suppression hearing on the use of the technology, right? No, they just decided they weren't going to go forward with the case on that particular day. So, and I'm going to get to this towards the end when we talk about the legal stuff about we have to look for this, and we have to challenge it. You may not actually succeed in getting the evidence thrown out in the sense of, oh, I filed a motion to suppress and I won, but that may be because your client's not in jail anymore, or because your client got a sweet deal that he never would have gotten otherwise if not for you poking around and asking questions about it. So that's Stingrays, this crazy stuff, Stingrays. I want to shift gears a little bit to talk about 2 other kind of secretive things that are going on that are under the radar that may be going on in your cases, especially if you have any drug cases like possession with intent or any cases that the DEA or you got agents that are cross-designated DEA where they have been involved in some kind of crazy shenanigans and have tried to hide up some of the stuff they're doing. So the first thing is called Hemisphere. Has anybody heard of the Hemisphere Program? Nobody's heard of the Hemisphere Program because it's been secret. So the Hemisphere Program is a program that was broken by the New York Times in September of 2013. And what the program is, in a nutshell, is it's a data mining program that the DEA runs and that local law enforcement can basically get information from. Let me unpack that a little bit. The Office of National Drug Control Policy is a branch of the White House. It's in the executive branch. And it basically does funding, and it allocates funds. They have set up these things called high-intensity drug trafficking areas, which you've probably seen, where these are basically collaborations between the DEA, the FBI, CBP, DHS, and local law enforcement agencies in certain drug corridors to kind of create an information sharing system where they can share tips and leads and information about criminal activity, especially related to drug trafficking. And what the HIDTA basically does is it sets up intelligence centers that allow law enforcement agencies to submit requests for information or to share tips and whatnot. And Hemisphere basically operates within that. And more specifically, what Hemisphere basically does, it's a database of call detail records available in near real time regardless of the carrier. What these records are basically records that AT&T has collected of communications that travel on AT&T switches. So by a switch, what I mean is the architecture of how a telephone call gets routed. So AT&T owns some telephone call equipment, and Verizon owns some telephone call equipment. But the reality is the companies work together to share basically that equipment. So that if an AT&T customer needs to make a phone call and there's no AT&T equipment or architecture nearby, they can seamlessly use the Verizon stuff, and then the AT&T will get billed by Verizon. This is how the telecom industry works. So as a result, even though these are only AT&T operated architecture, it has information from other carriers like Sprint or Boost or Credo or T-Mobile, whatever, you name it. They're also in that. And what Hemisphere is it basically collects all of this information, and it then allows for very detailed and complicated call pattern analysis for law enforcement agencies. So it has all these records. It has records going back like almost 10 years by one estimate. Another estimate is records going back to 1987. So even really before cell phones kind of existed, or at least existed as we understand them today. And they can basically be used for call pattern analysis. And what I mean by that is to find a dropped or new or additional phone number. Let's say your guy is sophisticated and he's watched The Wire and he knows you only use a burner phone. So he picks up one burner phone, he uses it for a month, he dumps it, he picks up another burner phone. Well, this will help the cops figure out what his new phone number is, because they'll do call pattern analysis. Let's say he's got 2 phone numbers, then they'll figure out both of his phone numbers. Let's say they want to figure out, hey, who else makes phone calls that are of similar patterns? They could use this and they could say, okay, here are the 3 phone numbers that have similar call pattern analysis, and they correspond to these 3 guys, and these guys must be in a conspiracy, or they must know the same people. Let's go find one of them or whatnot. Okay? So that's what this sort of call pattern analysis does. And it can be used to determine some location information. It can be used to figure out, hey, where is that guy at the time he made the phone call? What switch did he connect to? Well, if he connected to this switch, that means he's in this given area at that moment in time. And it can even get some call detail records on some international numbers that are roaming within the United States. Okay? Now, again, just like the Stingrays, this program operates in secrecy. This is a printout of a slide. So basically how the New York Times broke the story is some guy in Oregon submitted a Public Records Act, a FOIA request, and they turned over this training PowerPoint by accident that detailed the existence of this program. And basically, as you can see here, and you have, by the way, in the materials is the full PowerPoint slide deck that was reported, as well as some other PowerPoint slide decks that have been later revealed through other FOIA requests and litigation. And basically, as you see here, much like the Stingrays, what do you see? Requesters are instructed to never refer to Hemisphere in any official document. You don't refer to the secret call data analysis mining program that's operating in secret. You just say, we use the subpoena and we got records. Well, how did you know whose records to get? How did you make the determination that it was this guy's phone number that we needed to send the subpoena to? Hemisphere is the real answer, but of course, they're never going to reference that. In fact, there's a whole, and this is kind of paraphrasing some of the slides, there's basically what they call parallel subpoenaing, where they basically send an administrative subpoena to do the initial query. So an administrative subpoena, which judge sees an administrative subpoena? No judge sees an administrative subpoena, right? This is literally a rubber stamp. Like, I really actually think they have a rubber stamp that says administrative subpoena. So they issue an administrative subpoena, and think about how this would work. Let's say your cop has, I have an informant, and I have his phone book, and I'm not sure which of these phone numbers would be relevant, so I'm going to send all of the phone numbers in for call pattern analysis, and I'm going to just do it with an administrative subpoena, because an administrative subpoena requires no supervision by the court process at all, and I don't have to answer to anybody. So they send that. The analysis will come back and say, you know what? The 3 phone numbers that are the most important out of all of those phone numbers are these 3 phone numbers because of whatever connections to other people, etc. Then what they do is they say, great, we'll take those 3 phone numbers, and then I'm going to send a real good-looking subpoena that has the court stamp on it that's not an administrative subpoena. And then when I write the police report, I'll say what I did was I got a phone number, and I submitted a subpoena to Verizon, and Verizon turned that information over to me. And then it's walled off completely from the judges. It's walled off from the defense bar. It's walled off from defendants. Okay? And as they say, it's a pointer system. Pointer system. Just the first step. It just points you where to go. Yeah, except that this whole thing is basically operating in secret, is maybe illegal, is probably illegal. And you know, we're not even telling the judges about it. And then again, no reference to Hemisphere in official reports or court documents. Yeah, Jesus, it's crazy. Okay, no, that's okay. That's the reaction I'm looking for. Okay. Here, I want to highlight this case because, again, this shows you how the defense can use this to your advantage. This is a federal criminal case in San Francisco. This case is actually Ortiz. There's like 20 co-defendants. This specific the defense here is not actually Ortiz. It's a different guy. His name was Whipple. This was a gang murder case that was brought in federal court under RICO. Okay? Whipple, the main guy, he's looking at 3 mandatory life sentences for murder. Okay? In his discovery, the government turned something over to his defense lawyers that they probably should not have turned over. I don't even know what it was, but it was enough to trigger him to get a subpoena to the Hemisphere Program itself. And he got, and I don't know how it works in Delaware, but in federal court, basically, you got it, you know, for the defense to issue a subpoena, you have to get permission from the court to issue the subpoena, right? So he went to the judge, ex parte, in camera, made a subpoena request. Judge Ilston, great federal judge of San Francisco, she issued the subpoena. So this is what happened once he issued the subpoena. He issued the subpoena. He says he gets a, because he told me this. He said he got a call from the California Attorney General, Deputy Attorney General, who said, I got your subpoena request. I have no idea what the Hemisphere Program is. I'll get back to you. He then said, he got another call from the Deputy Attorney General who said, I just got a call from the U.S. Attorney. They're going to move to quash your subpoena. And they told me not to produce anything in response. So the U.S. Attorney moved to quash the subpoena. Now you tell me, how does a judge feel? Do judges like it when they've done something and then somebody else comes back and says, no, 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 Judge, you did it wrong. Can you, redo it for me or take back what you did? No, of course not. So Judge Ilston's like, no, I'm not quashing the subpoena. I issued the subpoena. It was proper when I issued. It doesn't matter what your complaint is. It's still proper. Turn over the information. You think they turned any information over? No. The guy got a plea to a 14-year deal. Okay? So he went from 3 life sentences to 14 years. Okay? Because they don't want to talk about it. They don't want to talk about it. And the biggest advantage that is to your client, who's going to get a good deal. You go from 3 mandatory life sentences to 14 years. And the guy had already done about 3 years in already. So just poking around and asking the questions and being aggressive on this can get you good results. There's a good article in SF Weekly that it's, again, the link is small, but it's in the materials that you can read that kind of details this whole case, because it's a crazy case. Yeah. Call detail records. So call detail records, this is basically who you call, when you call them, where you're calling them from. Okay? So this was, so that's the subpoena authorized the disclosure of this information. The subpoena was upheld on a government motion to quash. No information was produced, but the case basically went away with a pretty good deal for the client. I definitely think that there needs to be some strategy and discussion about that. And this goes back to something else I mentioned about the Stingrays. When you've got situations where you've got a documented history of police departments lying to judges, it really does call for a systemic re-examination of those cases. Now, what is the correct legal mechanism to do that? I honestly am unsure. I don't know if it's we're going to file a habeas in every case, or if it's we're going to go sit down with a DA and re-examine cases. In some departments, in some districts, the DAs are going back and reviewing the cases. I think that's what happened in Charlotte. They went back and reviewed the cases to see if there was Brady or exculpatory information there. As you can probably guess, the prosecutor said, oh, no, 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 it's all good, it's all good. But, you know, there is, I think, some room to play this out, and I'm happy to brainstorm that. I haven't put a lot of thought into exactly how that would look, but I think it's there. But you know, the first thing we have to do is we have to figure out who has this stuff and who's using it. And there are tools to do that, which we're going to get to in a minute. I want to finish, because I don't want to run out of time, I want to finish by talking about another program we learned about earlier this year, which was basically, you know, we've heard a lot in the news about the NSA. They're collecting all these records in bulk. They're collecting all the records of every phone call a person made. Actually, this morning, the Second Circuit just said that violated the statute, didn't authorize them to collect in bulk those phone records. That's a good win. They didn't talk about the constitutionality of it, but in any event. But basically, the DEA has actually been doing the same exact thing, but longer. Okay? So the DEA started in the 1990s, also started doing a process where they would collect in bulk the call records of individuals within the United States who made phone calls to certain countries that had a nexus to drug trafficking, okay? So what countries have a nexus to drug trafficking? Well, it turns out it was 116 countries that have a nexus to drug trafficking, okay? You know, like Mexico and Canada and Iran, who I didn't see that one coming, but sure, why not, okay? So, you know, basically everywhere, and they were collecting it in bulk and having it sit in basically in a massive government database that DEA agents and, you know, ostensibly state law enforcement officers who are cross-designated DEA or working on joint investigations could access that information. And that information, the CDRs, the call detail records, included the number that you dialed, the time and date of the call, and the length of the call. Now, they said, well, internally, our policy was we only queried this database if we had reasonable articulable suspicion that the number was associated with criminal activity. But, you know, again, the problem was they were collecting it on administrative subpoenas where there's no supervision, no judicial process, nothing. And anybody heard of the DEA's Special Operations Division? Okay, the Special Operation Division is basically the DEA's intelligence officers who do their international stuff. Like these are the guys that got Chapo Guzman down in Mexico. But they also, what they do is they pass tips on to local law enforcement and say, hey, we can't tell you where we got this from, but there's going to be a red BMW with this plate driving by, you know, 95 in like an hour. You should stop that guy. We didn't have this phone call. Okay? That's basically how it worked. And I mean, have you ever had a case where you're just like, man, the cops got really lucky to pull my guy over? You know? I talked to some lawyers in San Luis Obispo. This is on the Central California coast. And they said, man, the sheriffs here, they're so good at just happening to come across the beach when the panga boats loaded with drugs just happened to show up. And they go, we were patrolling in the dark beach at, you know, 2 in the morning. And all of a sudden we saw suspicious activity. And we saw a boat and it appeared heavy. And it had what smelled to be cocaine, which I didn't know cocaine had a big smell. Okay, anyway, sure. You know, this is what's happening. The information is being collected in one way. It's being funneled to law enforcement who come up with some pretext. Your guy was speeding. Your guy had a busted taillight. Your guy had this. Can we search? Do you mind if we take a look? And you know the rest of the story, okay? We call this parallel construction, or, you know, this is what's happening all the time in criminal cases, particularly in drug cases. So those are the programs, okay? So we've talked about the technology. We've talked about these programs. Let's talk about the law. How can we actually figure out, right? Going to what you were asking me, how do we figure out this stuff and what can we do about it? Well, obviously it starts with discovery, right? We have to start asking the questions. We have to start looking for this stuff. And, you know, when it comes to stingrays, look for other terminology, okay? So it may not be labeled a stingray, but maybe you'll see a digital analyzer or a kingfish, which is a later model of the stingray. Or you'll see references to the WIT, okay? That's the FBI's wireless intercept tracking team. Maybe you'll see references to a digital analyzer. That's a stingray, okay? Anybody here watch The Wire? Okay, of course, the public defenders, okay. So season 3 of The Wire, McNulty has a conversation with his buddy who's in the FBI. And he talks about some technology. It's a triggerfish. It's a stingray. They are literally talking about this stuff in The Wire. So you've got to go back and think, well, gee, the show is so realistic, and Simon knew all this information because he was a reporter. Well, yeah, because they actually have this stuff, and they call it different things. So you got to be on the lookout for this. The other thing to be looking out for is different descriptions of the technique. So you're definitely not going to see a reference to a stingray, but maybe you'll see something like, we tracked the cell phone. We pinged the cell phone. We used a known investigative technique to determine the phone number, to determine the location of the person. We did a ride-by. Okay, ride-by. That's out of Baltimore. Then I'll put up the transcript in a second. That's what they refer to it in Baltimore. I'll give you an example from the Northern District of California. This is a Hobbs Act robbery case in San Francisco that's actually pending right now in federal court. Okay, the government defense attorney gets this in discovery. Who's ever gotten one of these things in discovery? It's the incident log that the cops, you know, basically fill out. It's the Oakland Police Department. So they're basically listing all of the things they did. And what happened in Kincaid was the government made an initial discovery production. It included this. And, you know, it's easy when you get one of these things, you go, oh my God, this is all jargon. I'm going to have to like, you may tend to think to skim through it. There's stuff redacted. Well, the lawyer looked through it. He said, look, this production is incomplete. Give me more. And so they went back and forth, and then finally the government produced more in discovery than initially they produced. But in the second round of discovery, they turned over the same document, but it was unredacted. Okay? And what did it reveal? Well, what's highlighted was what was unredacted that was redacted the first time. So when you start to think about redaction versus unredaction, something that was redacted is no longer redacted. What does that say? Or vice versa. Something was not redacted the first time, now it's redacted. What does that say? Well, you see here it says ping suspect phone. This was, the government later acknowledged in a court filing that, yeah, that's the Stingray. So that's the reference, that's the only reference to the use of the Stingray in the case, was that little blurb right there, ping suspect phone. So you've got to know how to look out for this stuff. And it's tricky because we don't even fully know how they're hiding this stuff. We have good ideas. We have a lot more information than we did before, but we're still going to have to dig a little bit. Here's another one. This is out of the Baltimore case, State versus Taylor. And again, this is the cross of the officer. Okay? The officer said, what he basically, there's two officers testified. This is the guy who's writing the search warrant in the police office. He says that he called another officer to do a ride-by to make sure the cell phone they were looking for was still in the house. Okay? So he said, yeah, I just called to make sure the phone was there so I don't waste my time writing the search warrant if the phone's no longer there. So the cops did a drive-by to see if the phone was there. Well, how did they know whether the phone is still there? Because they used the Stingray. And the Stingray says, yeah, the phone's right there. Okay? What happened after this cross-examination was the government said, okay, we're not going to use any of that evidence, so we don't need to talk about this anymore. Right? We didn't even get to the next step, right? Like the first step we're talking about is just figuring out whether this thing even is around and used. We're not even, like we're just at the beginning of the litigation. And I don't mean that like specifically like in this case, but I just mean like as a defense bar overall. We're just scratching the tip of what's to come, which is to start challenging what is reliable, what is, and part of that's going to be actually looking at that data, which we haven't seen yet. I think it eventually hits the nearest cell phone tower, meaning it doesn't replace the cell phone tower. It's more like the signal goes through the Stingray first, then to the cell tower. So it's really intercepting it. And we've actually seen records that with the proper additional equipment, which I doubt a lot of local law enforcement has because it's very expensive, but the feds have this, that they can add on additional equipment to basically say, when the signal goes through, not only are we capturing the IMSI number, but we're actually capturing phone calls or text messages. Meaning they could use this, when configured with the correct additional technology, they can use it as a wiretap, okay? Again, that's not what a Stingray in isolation is. It has to have other equipment, but it is technically possible to do this. It's not, if the cops say, you'll see a lot of the agencies will say, well, we're not capturing phone calls. And it's not because it's impossible to do it. It's because A, the law is going to make it a lot more difficult for them to do it unless they get a wiretap order. And B, for most state and local law enforcement, they don't have the equipment to do it. But the feds definitely have the equipment, and we have documented evidence of that I can show you guys later afterwards. I think it's too expensive. So I think one piece of it is, there's a couple. One is cost. The technology is expensive. The second piece of it is the law, because they're going to argue, and we're going to get, this is actually a good segue to my next point, which is they're going to argue, well, we don't need a search warrant to operate this thing, right? But they definitely need they don't even need a warrant. It's not that they just need a warrant to do a wiretap. They need like a wiretap order to do a wiretap, right? So the legal threshold is much higher. So I think that's a second barrier. And I think the third point is a very interesting one, that this stuff generates a lot of data, and I think a lot of the departments don't yet have the institutional capacity to handle that. Now, that's not to say that that could change in the future, and I think there's a real possibility that that does change in the future, but for the time being, I really think they're only using it in this narrower piece. Maybe I'm wrong, and if I'm wrong, then, oh boy, I'm going to be employed for like 20 years after this. This is going to be great. So that's the discovery piece of it. Let's talk about the law very quickly, like the substantive law, and then we'll do questions. ultimately, if we're thinking about it from like a matter of search and seizure, we're thinking expectations of privacy, we're thinking Fourth Amendment. Ultimately, the Supreme Court has said that, look, when you talk about an expectation of privacy, you have to actually reference something that is understood and recognized as an expectation of privacy, right? Like, when you try to explain to a non-lawyer what the Fourth Amendment means and what a search means and what CATS means, and they go, well, you have a subjective expectation of privacy that society considers as reasonable. And they go, what does that mean? And the courts basically said, well, we don't really know what that means. It means that if we like it, we're going to let you do it, and if we don't like it, we're not going to let you do it. But basically, what the doctrine says, it says this. It has to have a source outside of the Fourth Amendment, and it has to be a reference to an understanding that is recognized and permitted by society. The other thing that Raka says is, or it has a relation to a property interest, which makes some explanation for why the Supreme Court in the GPS case in Jones said, yeah, if you trespass onto someone's private property to gain information, you're violating their property interest, and that's a Fourth Amendment interest. But that's we're not really dealing with that here. We're talking about expectations of privacy. So 1978, Supreme Court says you need to reference something. Well, fortunately, in Riley, okay, I'm sure everybody knows Riley, great case, that said, cops can't search a cell phone incident to arrest, or they can't search the data on a cell phone incident to arrest without a warrant. This is the important takeaway from Riley. And there are two. First is that a privacy interest, and I don't mean privacy in some sort of global human right, which is important, but I mean privacy in terms of an expectation of privacy under the Fourth Amendment, that it depends on the quantity and quality of information that is revealed to law enforcement. How does that come up? Remember that in Riley, what the court said was, actually, let me back up. In Riley, if you remember, what the government was basically arguing was a cell phone, legally speaking, is no different than a pack of cigarettes. They are the same thing, okay? Because if you remember, in the 1970s, in a case called Robinson, U.S. Supreme Court said what? They said when the cops search someone incident to arrest, they can search physical containers found on their person. So Robinson involved search of a pack of cigarettes in the guy's jacket. And basically, a lot of the lower court decisions that were basically trying to figure out the cell phone issue were basically saying, well, a cell phone's like a pack of cigarettes. They both carry stuff, okay? And I mean, you laugh, but that's I'm ashamed to say this. That's what the California Supreme Court said. They said, oh yeah, there's no difference. The Supreme Court never said that the privacy interest depends on the type of thing you search. So, searching a pack of cigarettes, which holds, cigarettes, and your cell phone, which holds, everything about you and your, friends, family, your pictures, your selfies, your porn, your whatever, okay? We know it. It's okay. No, I have to admit it, okay? Those are the same thing. That's what the California Supreme Court said. I'm ashamed. My home court, they said that. No, and of course the Supreme Court said, no, of course not. That's silly. In fact, they said what? They said, that's like saying a horse, a ride on a horse is like taking a rocket to the moon. They both get you from point A to point B, but basically nothing else justifies lumping them together. And that's Chief Justice Roberts saying that, okay, which is amazing in and of itself. And so they recognize that the privacy interests depend on the quantity and quality of information revealed. So even though, the Supreme Court has also said that you have no expectation of privacy in your public movements, and that you have no expectation of privacy in information you reveal to a third party, like your phone records, those cases don't deal with the same type of privacy intrusion that a Stingray captures. Your location in real time at any given moment in time. It doesn't deal with the situation like Graham, the cell site tracking stuff, where they're talking about tracking a person's movements over 6 months and going back in time to recreate his movements. The government nobody has a time machine, except when it comes to your location. Then they got a time machine, right? But the cops couldn't actually say, you know what? We don't need the cell phone data. We'll just hop in our time machine and figure out where he was 6 months ago. They can't do that, right? So it's the cell phone data that gives them that information. So that's how we can defeat these barriers. And more specifically, when we're talking about how to kind of fit it within the CATS rubric, this expectation of privacy rubric, we got a couple arguments. First, when it comes to the subjective expectation of privacy, that location information is revealing, particularly when it's stretched out and aggregated over an extensive period of time. And second, and I think this is really important, that your phone records may actually be protected under the state constitution. Now, generally the Fourth Amendment kind of doesn't care about what state law says, right? And they basically, there's a bad Supreme Court case called Virginia v. Moore that says, the Fourth Amendment is not a redundant guarantee of state law protection or statutory protection. So that's probably, I don't like that, but it's true, so you're stuck with it. But that doesn't mean it doesn't matter for figuring out whether I have satisfied the subjective prong. In other words, if I live in a state, let's say I live in Massachusetts. Massachusetts has said you have an expectation of privacy in your cell phone records. Okay, in your cell phone location records. If I live in Massachusetts, and I'm a Massachusetts resident, and the Massachusetts Supreme Judicial Court has told me, Hanni, you have an expectation of privacy in those records, then why would it be unreasonable for me to have a subjective expectation of privacy in those records? Are we going to say that, well, it doesn't really matter what the Massachusetts Supreme Court says, it's just dicta? No, that's what they've promised me. I'm going to live up to it. I'm going to accept that as my legal right. So that at least goes to the subjective prong, even if it doesn't solve the ultimate question or answer the general Fourth Amendment question. But it satisfies the subjective prong. The second thing is that expectation is objectively reasonable as the body of case law grows and statutory protections grow for this information. In other words, you can string together an argument that says, state law provides me at least some subjective expectation of privacy, and as more states adopt warrant requirements for this information, it becomes objectively reasonable to say that it's reasonable to have that expectation of privacy. And then, of course, to get around Smith and this idea that records turned over to third parties aren't protected by privacy, by the Fourth Amendment, you basically say the nature of the intrusion doesn't apply. Riley didn't just blindly apply Robinson didn't just say, well, cell phone and cigarettes are the same thing. They're not. And the result is we're starting to see some good case law come out of this. Now, this is a case out of the San Francisco District Court that basically just took this argument and accepted it. Now, the flip side is, and I'll put this up real quick, and there are some states that have said, look, you need a warrant to track a car with GPS. There are states that have said you need a warrant by statute to track a cell phone's location. Okay, Delaware isn't anywhere on here. In Pennsylvania, there is a Pennsylvania appellate court decision that says you need a warrant to obtain cell phone records. There's also a New Jersey Supreme Court opinion that says you do. Now, check out the but C. The but C shows all the cases that have not agreed with this, that have said a warrant is not required to track a cell phone. And if you'll notice the first case, Davis was decided 2 days ago. It was out of the 11th Circuit where they said, no, there's no expectation of privacy in these phone records. So the federal courts have been bad, but thankfully you guys all practice in state court. So you have an opportunity to develop state law. Maybe if your state constitution basically tracks the Fourth Amendment, well, that's going to be an obstacle. But there is some play here. The courts are divided. They're kind of going all over the place. And if you're thinking about the Third Circuit, what the Third Circuit has said is when it comes to cell phone records, they've said a judge may, but is not required to require the government to issue a search warrant. So good luck applying that law. That's, I don't know, that's confusing. So with that, I'm going to open it up for questions. So I don't think there's any operational costs outside of buying the device and getting the training for the device. So theoretically, they could use the device anytime they want. And we've seen it used in murder cases, robbery cases. We've seen it used in a tax fraud case. So I think it really does depend. I think the other area where it may depend is on what is the legal process they're using this. They're using the devices. A lot of departments are just using it, period, and not going to the courts. Some are going to the courts and getting at least a pen register order, which has, I'm sorry? So a pen register, do people know what a pen register is? Okay, so a pen register, it's kind of an old school thing now. So a pen register is basically, if you think back of the old days when you used to have a phone company would switch and connect your phone calls. Pen register would allow the phone company to record which phone numbers your phone dialed, and then the cops could use that and say, okay, well, he dialed this person and that person and that person on that day. So all a pen register does is it's a piece of technology that captures that information. In the modern age, in the 21st century, when people don't use landlines anymore, a pen register could still be used to capture dialing and routing information from your cell phone, but it can also be used to capture internet dialing and routing information. And you may be thinking, wait, internet dialing, what does that mean? What I mean by that is you send an email. Well, when you send an email, you're sending it from one internet location, one IP address, and it's being sent to someone else who receives it at a different IP address location. Pen register would allow the cops to get that routing information, to figure out who you're communicating with and how you're communicating with them, even though it doesn't allow them to get the actual communication itself.
And it doesn't have location.
Pen register? It's on, if you think about a landline, probably not. If you think about a cell phone, it may, because it would have the cell tower information. Now, there is, and it gets a little complicated, and I don't want to lose everybody in the weeds, but there is some provisions of federal law that say you're technically not supposed to use a pen register to get location information by itself, but there's a separate federal statute that allows law enforcement to basically get location information without a search warrant, but they still have to go to court. And even a pen register requires a court order. It's just that the standard is very low. It's a reasonable standard, or relevant standard, sorry.
So I got one.
Okay, well, we should come talk afterwards. So then, yeah, let me, yes. Yeah, that's a very good question, and that is a major hurdle. And if you go back to the federal cases, so I mentioned the 11th Circuit just a few days ago, that's exactly what they said. They said when you make a phone call, you're giving up your location to Google, or actually to Verizon or AT&T, so you can make your phone call. And basically what the 11th Circuit said is, and if you don't want to do that, and you want to preserve your privacy, just turn your phone off, okay? Which, you know, good luck with that, okay? So the courts that have reached the opposite result, however, and there have been a lot of courts that have reached the opposite result, have basically said, nah, this is not a truly voluntary decision, first of all, because a cell phone is not a luxury, right? It's a necessity, right, in modern society. 90% of Americans, Pew has found, 90% of Americans have a cell phone. So the idea that there's actually a real choice involved is not correct. The second thing the courts have said that have accepted the privacy arguments have basically said there's a difference between revealing, there's a difference between privacy and secrecy, okay? Privacy means you control who gets information about you, and you have some ability to condition who gets it for what purposes. Secrecy is different. Secrecy is like you don't tell anybody anything and you keep your mouth shut. But privacy is about control. So that when you convey information to the cell phone company, only for the purpose of routing your phone call, you're not also saying, oh, and just do whatever you want with it, okay? Now, that is a very subtle point. That is a very debated point in the cases. Basically, some courts have said, yeah, we buy that. Other courts said, nope, that's ridiculous. And there is a significant tension in that area. And when I hear there's significant tension in the law, I hear, great, there's legal issues that can get litigated and preserved on appeal. Maybe I'll lose them. Maybe I'll win them. Maybe the government, the DA doesn't want to deal with it and is going to cut my client a deal. Maybe I'm going to get my shot at the Supreme Court to argue it. And, so, I mean, I think it's important that even though it may seem like an uphill battle, you got to raise it and think about it and litigate it and preserve the issues. And in the materials, I've within the materials is the PowerPoint, there's other PowerPoints, but there's also like amicus briefs that we've written and ones that we filed with the ACLU of Northern California that, is the blueprint for how to make this argument. And the reason I give you the amicus brief is not to admire my beautiful writing, but to basically say, you should just change the names and file this, okay? And that's, because I was a federal public defender. I didn't have time to write 30-page amicus briefs on what the Fourth Amendment means. I had 50 other things to do. So that's what EFF exists for, to help you. So just email me or call me or whatever. Don't send me a letter. That'll take too long. But email me or call me, and I'll help you out in that regard. Are there other questions? FOIA and state-level PRA, and I actually think state-level PRA is way better than FOIA because it's much faster, is a good long game tool. It's not going to help your individual client when he's got a trial in a month. But if your office, and I'm just using this generically, I'm not talking about Delaware specifically, but if Delaware or any other office wants to think strategically about what are requests that we can make that we can think long game for, that's a good resource. And if you don't want to do that, then call me, and I'll do it for you, okay? Maybe not in Delaware, but we can think strategically because you guys see what happens before I see what happens. So if you see something that you're like, you know what, this is ripe for, there's something fishy here, I would love someone to look at it, give me a call, and then I'll look into it, and then maybe we'll be the ones that do the request. And we'll give you the credit and send you some T-shirts, too. Okay? I think my time is up, but I'll stick around and answer questions afterwards. Thank you.